And I'll say good morning to everybody and welcome to the first edition of The Box. This is Mills Reeve's brand new webinar series for insurance brokers, intermediaries and their insurers. My name's James Thompson. I'm a principal associate in Mills Reeve's insurance disputes practice. I spend a lot of my life advising brokers and intermediaries on risk management and claims issues. I'm delighted this morning to be joined by Natalie Simpson from Starr Insurance Companies. Good morning, Nat.
Hi, James. Firstly, thank you for inviting me to chat with you today. I'm a financial lines claims adjuster with Starr Companies. I've been here since December 2019, and prior to that, I've got 4 years London market experience.
Fantastic. It's like a job interview.
Absolutely.
Okay, so this morning, Nat and I are going to be talking about risk management for cover holders and MGAs. So if we could move on to the next slide, and I'll let you know what we're going to be talking about this morning. Understanding delegated authorities. We'll have a trot through the law of agency. We're going to look at conflicts of interest and managing broker relationships. And then we'll wrap up by talking about binder breaches and disputes. So if we move on to the next slide and move straight into understanding delegated authorities. You all as cover holders and MGAs are agents of insurers. That is the nature of the business model. You agree with insurers what you're going to have authority to do on their behalf. And typically that agreement between the insurer as principal and the cover holder or the MGA as the agent is set out in a delegated authority or binding authority document, a contract between the parties. Nat's going to talk for a moment or two about the nature of delegated authorities.
So this is what's actually contained within that document. What authority have you been given to write on behalf of that capacity provider? This can be various different things. It could be financial, in terms of excess, limits of indemnity, or it could be lines of business. So certain lines that you're authorised to write and others which you aren't. Incorporated within this document, there'll also be trigger points. So areas that need to be referred into insurers for authority. This allows insurers to stay close to what's being written while providing the cover holder with some autonomy, quite a lot of autonomy, I would say.
Fantastic, thanks, Nat. So that is actual authority. If we can just move on to the next slide and we'll look at implied authority, because a lot of what you do in your day-to-day working lives will not necessarily be set out in the delegated authority document, but that doesn't necessarily mean that you're not entitled and authorised to do it as a matter of law. The law will provide you with, as I've set out on the slide, the further authority to do all things necessary in the ordinary course of business for the efficient and proper performance of your duties, in line with market practice. So all of the things in your day-to-day working life to run your business as a cover holder or MGA that people would expect of a cover holder or an MGA. An example of implied authority could be, for example, where you've got some claims handling authority. You could be dealing with a policy where the dispute resolution mechanism under the policy is arbitration. You generally have the implied authority to refer a dispute under that policy to arbitration, utilising your implied authority. If we just move on to the next slide to talk about assumed authority, because we looked already at actual authority under the contract, an extension of that authority under implied authority, but there could also be situations where you as a cover holder or a managing agent hold yourself out to a third party, to a policyholder, as having the authority to do something, to make a decision on behalf of insurers, when in fact you do not have that authority. If you are making that decision, and it is the sort of decision that is generally in line with market practice, but is outside of the scope of what one would consider to be within your implied authority, then the policyholder is very likely to be able to rely upon that decision, upon the assumed authority that you have held yourself out as holding, and the insurer would typically be bound by a decision that you had made on their behalf, utilising that assumed authority. But the key thing with assumed authority is that it is not actual authority in law. So whilst you've held yourself out as having that authority and the insurer is bound, the insurer may also have a right of action against you for the breach of the delegated authority that's been provided. And again, we're talking about decisions and acts that are in line with market practice. Anything where we're considering assumed authority has got to be plausibly within the scope of what you could have authority to do. A caveat is around notices of restricted authority. If a policyholder or a third party is on notice in any way that you do not have the assumed authority that you were holding yourself out as having, then they won't be able to rely on it. So if you're in a situation where you're defending a claim that's brought against you on this basis, you need to be thinking about the proposal form, the policy documents, any temporary cover notes that could have contained some sort of warning that you did not hold this particular authority. An example of assumed authority could be where you typically need to collect the premium before the policy incepts, but you reach an agreement with the policyholder to defer the payment of the premium. The policyholder would be entitled to treat the policy as having incepted and being valid. The insurer may well be bound by that, but the insurer may be coming after you as the agent for the loss that it suffered as a result of that breach. And if we can just move on to the next slide. Just want to talk quickly about fraud and cover holders and managing agents acting in their own interest. Sure, we've got no dishonest cover holders or managing agents on the webinar this morning, but in a situation where cover has been placed in line with a form of authority, so in line with actual authority under the delegated authority agreement, implied authority or assumed authority, then even where the agent is acting in its own interests and could, for example, be pocketing the premium for their own benefit, the third party, the policyholder, would still be in a position to enforce that policy as against insurers and to treat that contract as valid because the agent has had the requisite authority to incept the policy. Again, that does not mean that the insurer is not going to be coming after the agent in respect of its loss, and I'm certain in circumstances of fraud, they're absolutely will be pursuing that with vigour. If we can move on to the next slide. So I want to talk briefly about ratification. What if an agent acts outside of its assumed authority? Well, the agent can only bind the insurer if the insurer has ratified the decision. Ratification can be express, so an insurer can simply say, notwithstanding that the agent did not have authority, we are now prepared to stand by the decision that they have made. Or more dangerous for insurers, ratification can be implied. And in a situation where perhaps insurers haven't noticed that their agent has exceeded their authority, they could proceed to treat the claim or the policy as valid, and only realise further down the line that perhaps there has been a breach of authority, but by which time it may be too late because they may well have waived their rights by ratifying the agent's decision. So if we move on to the next slide, we're going to talk about conflicts of interest. Nat, do you want to take us through conflicts of interest and managing broker relationships?
Conflict of interest is a really interesting one. I think it's a real risk point for broker cover holders. There's sort of 4 really good examples there of things to watch out for. For broker cover holders, you're balancing the interest between your clients, but also your capacity provider. You walk quite a fine line in that respect. So you have to make sure that you have best interest of both parties at heart. Broker-owned MGAs, there tends to be a feeling by clients that brokers who own MGAs only have a vested interest in the company. So you need to take care that you're not preferring one interest over the other. Key broking relationships, capacity providers will have relationships with others within the market, and they will want certain relationships protected. It's important that you acknowledge that and respect it and be careful with those relationships as well. They're important to capacity providers. But also you'll have your own broking relationships that you'll want to protect as well for your individual company. Finally, your obligations to insurers, and this goes back to what James and I were talking about earlier with actual authority. You owe that insurer an obligation. You need to be careful to make sure that you're balancing everybody's interests appropriately. I think the real thing with conflict of interest is the fact that it's kind of twofold. One, you need to be very careful because there's a professional indemnity issue around that. But also you need to make sure that you are balancing these interests for your own longevity, your own commercial longevity within the market, and also the insurer or the capacity provider's longevity as well. Reputation is important to both parties.
Great. Thanks, Nat. If we just move on to the next slide, just one short point on conflict of interest that I wanted to raise was for cover holders in particular. Cover holders who may well have a broking side to their business, or even if they don't, there is a risk of cover holders falling into the trap of holding themselves out as acting as a broker for a policyholder. And just to flag the real danger, if you find yourself in a situation where you are a cover holder as the agent for an insurer, but you may also have held yourself out as a broker acting as an agent for a policyholder, and in any dispute between the policyholder and the insurer, you're going to find yourself having to deal with a conflict of interest because it will be impossible to act in the best interests of both of those parties. So I just wanted to flag that as a particular issue on conflict. We can move on to the next slide. And we're going to talk now about binder breaches and disputes. Binder breaches and disputes can obviously occur in relation to any aspect of the cover holder or managing agent situation around underwriting, risks that have written that should have been referred to capacity providers, claims that have been settled outside of authority, or perhaps coverage issues that should have been either flagged pre-inception, identified on proposal forms, or notified to insurers during the course of a claim. If we can just move on to the next slide and think about the different sorts of claim that you could face as a cover holder or managing agent. And it's important to flag that you could be facing a claim from either your capacity provider in breach of contract, going back to the delegated authority agreement. A breach of that agreement will be a breach of contract, and so a breach of contract claim could be advanced against you. Equally, as a managing agent or a cover holder, you owe a duty of care to your capacity provider to provide your services to the standard of the reasonably competent cover holder or managing agent dealing with your particular class of business. And so you could be facing a common law claim for breach of your duty of care. You could also face a claim from a policyholder. Think about a policyholder who has been left uninsured as a result of the agent's actions. So a situation in which a policyholder believed that they were insured in respect of a particular risk, but that cover is now not available because the agent has breached its warranty of authority. And the important thing to flag about a breach of warranty of authority claim is that liability is strict. So the policyholder does not need to demonstrate negligence on behalf of the cover holder or the managing agent. They don't need to look at questions of causation. If they can demonstrate that the breach of warranty of authority has resulted in their uninsured loss and the loss that they have now suffered, then liability will be strict, and you as an agent would be on the hook for that loss. So if we move to the next slide, Nat's now going to wrap up dealing with some practical tips around binder breaches and disputes.
There's some really simple steps that you can take to try and avoid any kind of binder breach. The first one that I would flag up is you can do things like have internal checklists in place, make it really simple. Have those authority documents somewhere where they're easily accessible, whether that's on a shared drive or hopefully when we're back in the office in a hard copy document that people can easily refer to. We talked about these trigger points to insurers, but maybe think about putting in further trigger points for more junior members of staff so they get that double checking to make sure that they're acting within their authority. One of the absolutely key things I would suggest is that you build a rapport with your capacity provider, have that relationship with them where you can pick the phone up to them, or you can send them an email to just ask them a question. As an insurer, we would far rather you asked than you guessed and you breached. Ask insurers to come in and do some training. We'd be more than happy. It's always nice for us to come in and to meet our cover holders and to work quite closely with you. So please just ask if we can provide training that would assist. In the situation that there is a breach, the first thing that I would suggest is that you go to your internal risks team and have a conversation with them. They may advise that a notification needs to be made to the professional indemnity insurer, but they'll be able to provide you with guidance around that. And both your internal risk team and your professional indemnity provider will be able to give you some guidance on how to approach the capacity provider to inform them of the breach. So it's all about being very open, being very honest. But my absolute top tip and takeaway would be, if in doubt, refer to insurers.
Great advice. Thanks, Nat. And that's all from us this morning. As I say, if you have got any questions, please do post them in the Q&A. I'll have a look in a second to see what questions we may have. Nat, if you just move to the final slide, actually, the farewell slide. It's not quite farewell. I just want to let people know that the next edition of the box will be on the 20th of April. My colleagues Neil Frankland and Andrea Stanford are going to be talking about conflicts of interest for insurance brokers. So that's the 20th of April. Invites will be coming out shortly for that. Great. Nat, any questions?
Yeah, so the first one we've had come in says, if insurers say that I should have referred a risk and that they would never have written it had it have been referred, what evidence would they need to produce to be able to demonstrate that?
Sure, that's a really good question. And it's something that I deal with a lot. Situations where insurers typically will assert that they would never have written the risk that has turned smelly, and you get into quite protracted disputes around evidence, and insurers need to evidence that. You're looking at underwriting guidelines, which is something that insurers are always very, very sensitive about disclosing. And so if you're defending a claim against a cover holder or managing agent, and you are truly in dispute with your capacity provider, really pressing for their underwriting guidelines, I think can be a very, very useful pressure point. Very often insurers are very reluctant to hand those over, and it sometimes is where these disputes can really do open out, because insurers are not willing to hand them over. In circumstances where the underwriting guidelines aren't helpful to insurers, or perhaps they're ambiguous, then you're going to be looking at witness evidence from underwriters. So really insurers demonstrating, well, as a matter of practice, when faced with risks with these particular features, it is our common practice not to write those risks. And I see lots of situations with my cover holder and MGA clients where they say, well, hang on a minute, I don't believe that evidence, because I can think of examples of risks where perhaps a situation like this has been referred and it was written, and so that can be really helpful kind of in response. But it's really about kind of getting under the skin of what would insurers have actually done if they had been referred a risk and had to think about it. I've got a question for you here, Nat, actually. It says, you've talked a lot about the pitfalls of being a cover holder, but what are some of the benefits of these types of arrangement?
Nice. I like that, kind of turning it on its head. I think there's advantages for both capacity providers and for the cover holders. I think certainly for the cover holders, it allows you to write very bespoke insurance, but you've got a recognized and commercial brand that backs you. And that's quite attractive for clients to have somebody that, maybe it's a name that they know, they're familiar with, which is always appealing. It gives you more scope within the market. It's far bigger business for you to write. And certainly from a capacity provider's perspective, it actually allows us to write better business. You know, brokers tend to be much closer to the clients. They know those kind of niches, those unique elements that they need, and it allows us to actually know what's in our book and what's in there and what's out there, and to be more selective with what we write. So I think it's a really mutually beneficial relationship for both capacity providers and cover holders.
Yeah, absolutely. Great. I've got a couple of other questions that might be more for me, I think. Sean Finnegan asks, a broker has a DA and places their client on cover. A dispute subsequently arises, for example, on the duty of fair presentation. The policyholder pursues the broker for poor advice. How would this be handled? I think it very much depends, and it comes back to one of the points I made during the talk. Are you acting as a cover holder or as a broker? And it sounds from the question that you're clear that you are acting as a broker, and your policyholder is pursuing you because you've not presented their risk, or they say you've not presented their risk adequately to insurers. You need to be really clear on where your duties lie here, and I think if you have a business model where there's any ambiguity as to, well, am I a cover holder here and am I insurer's agent, or am I truly a broker and am I the insured's agent? Because otherwise you're going to have the risk of facing a claim from both directions, because the insurer could say, well, we are not, we're going to take a point on the duty of fair presentation. We've suffered prejudice. This risk shouldn't have been written. Equally, your policyholder client says, hang on a minute, for whatever reason, I gave you this information, you didn't advise me about what was material or not. So I think as to exactly how it plays out, it depends upon really whose agent you think you are, and if you've got ambiguity around that, then it's going to be quite a difficult claim to deal with. So it's not a clean answer on that, because I think it would be totally fact specific on the particular situation, but that's the real risk. And a final question just before we wrap up. If a binder is not renewing, what duty does the cover holder have regarding telling brokers and when? I think it's more a question of commerciality. The broker is the agent of the policyholder. As a cover holder, you are the agent of the insurer. You as the cover holder, you don't owe the broker a duty. It's the broker's job to go and find cover and to make sure they get the renewal process going in time. If there's a if there's an issue around timing and not providing sufficient notice that a book's not renewing, I think that could be professionally embarrassing for you. It might lead to kind of poor broker relationships, but I'm not convinced that it's something for which a cover holder is not going to be liable to brokers in respect of that sort of situation. So it's more of a commercial than a legal question, I think. Great. Well, those are all the questions that we have got. I hope everyone's found it useful today. Thank you very much to Nat from Starr for joining me. That's been great, and thank you very much, Nat.
Thank you for having me.
Brilliant. And we will leave you all to get on with the rest of your days. As I say, the next edition of the box is 20th of April, dealing with conflicts of interest for brokers, and we hope to see you then. Thank you very much and goodbye.